SJC-11974, Commonwealth v. Harvey J. Bigelow.
Good morning. May it please the court, my name is
slow
I'm
down.
sorry.
Wait, 1 second. This is Bigelow.
Okay, thank you.
Thank you. May it please the court, my name is Diana Cowie McDermott, and I represent Mr. Bigelow in this matter. Mr. Bigelow was convicted of 2 counts of criminal harassment in violation of 265, Section 43A. There were 2 listed complainants. One was Michael Costello, a Rehoboth selectman, and his wife Susan Costello. The defendant was sentenced to 1 year straight probation. One condition was that he write a letter of apology to the complainants and that that letter was to be published in 3 local papers. Those papers were identified by the Commonwealth. The Commonwealth also requested that the defendant be required to stay away from Mrs. Costello, but not against the selectmen. Below, the Commonwealth described the 5 letters in questions as, quote, displeasure with the selectman's performance in his position as a selectman. On appeal, the Commonwealth says that all 5 letters, quote, that the selectman is the obvious subject of all 5 letters. On appeal, the Commonwealth does not argue that the subject of the letters are fighting words or true threats. Rather, and if I may add, in the facts section of the Commonwealth's brief, they point to letter number 2, where, and the Commonwealth says that the writer writes, "You should resign or else." It is true that letter number 2 does say that. However, that is an incomplete thought because the writer goes on to say, "Resign or else be put on administrative leave." So I suggest that that is no threat, as the Commonwealth may be suggesting. The Commonwealth also mentions in their brief that all 5 of these letters have violent overtones. The Commonwealth does not point to anything in specifically. Finally, the Commonwealth references letter number 4, which is a letter addressed to Mrs. Costello, and there's a reference to Jim Jones. The Commonwealth, I think, is maybe suggesting, again, it's in the facts section, not in the argument section, that the letter number 4 says to Susan that the selectman exercises his strong arm. Don't be so stupid to be subject to that strong arm. Don't be like Jim Jones. There's some reference to that. The bottom line is none of these references make out a fighting words or true threats. And in the argument section, the Commonwealth does not argue that these letters fall under fighting words or true threats. Rather, the Commonwealth argues that Commonwealth v. Johnson dictates this case. This court may recall that that's a 2015 case. That case does not dictate, first because this case predates Johnson. This defendant was convicted in 2013. The criminal complaint issued in 2011. Johnson occurred, it was decided in 2015. Nonetheless, the Johnson case is not does not dictate this case. The court may recall in Johnson, the defendant who was charged with criminal harassment, by way of a third party, posted on Craigslist an ad falsely indicating that the victims were were giving away a free golf cart. This caused tons of people to appear at the victim's front lawn, repeatedly demanding for this free golf cart. Also, the defendant in Johnson also posted on Craigslist indicating that a bike was for sale. And that caused people to repeatedly call the victims throughout the night asking about this bicycle. Finally, the defendant in Johnson also contacted the Department of Children and Family and said that the victim, the male victim, was abusing his son. This court held in Johnson that 43A is directed towards conduct. And when speech is integral to conduct, that speech is not protected when in furtherance of a criminal violation. When the sole purpose of speech is to further that conduct in violation of a law, it will not be protected. In this case, the Commonwealth is alleging that the defendant's alleged mailing these 5 letters is the conduct. The Commonwealth's logic does not hold up. That is to say, if anyone should write a letter to any person, then they could be subject to this violation.
Can I ask you, does it make a difference who the person is? Are you saying that it would be protected speech no matter who the target was?
Yes, I am, Your Honor. I think the fact that one complainant is a selectman puts him in a different light. He even testified that he, as a public figure, opens up himself to criticism. He accepted that. And I think that that is a fair assessment. He has interjected himself into politics. Just as he's open to hearing praise, he must be open to hearing negative comments. And so the entire tone of the alleged letters is expressing dissatisfaction. This writer thinks that the selectman is doing a lousy job, and he thinks he is not qualified as a selectman and should step down, and he has said so.
Right, but I'm saying, I guess my question was, I thought you were making an argument that because the letters, the sending of the letters themselves is not the type of conduct that would render the speech unprotected.
Yes, the mailing is not what protects the speech. It's the actual words that deserves First Amendment protection. It's not the mailing. In Johnson, this court made clear that the speech set in motion conduct. So as I said, for example, the posting with the free golf cart, that caused people to appear at the victim's home.
And nothing happened as a result of this, is what you're saying?
That's right. There's no, exactly. In Johnson, there's a component of causation. The words caused conduct by some party. But in this case, that causation component is not present. This defendant allegedly expressed his views that the selectman was not doing a good job and not qualified. He never asked anyone to do anything, and in fact, no one ever did do anything.
Does the truth of the statements matter?
I think the fact that he's entitled to his opinion is what matters. So he, for example, said that
Well, let me step back. I mean, in Johnson, it would have mattered if the person truly had information that the parents were abusing the child, I would think, and said, I'm going to report it to DCF. That would have been a somewhat different position from in Johnson, where that was a totally baseless charge. Does the truth bear on any of this?
Well, in Johnson, if that was true, then it would not be subject to the statute. But in this case, I think that the fact that there may be some truth still protects a defendant. He can still speak the truth.
Was there any evidence that it was not true, by the way?
I'm sorry?
Was there any evidence at trial that that the information in these letters was false?
Mr. Costello, the selectman, did testify generally all 5 letters were lies, and he characterized them as slinging his reputation through the mud.
Including the information about the prior convictions?
Yes, as I say, it was just a general statement. Everything was lies. He was not asked specifically that question, but as a general statement, he said, all of it was lies. It dragged my character through the mud.
Mm-hmm. Does it make any difference in this case that the defendant was trying to get the selectman to resign, and one of his strategies was to essentially ruin his marriage, ruin the selectman's marriage by sending letters to the selectman's wife, saying that this guy's having an affair. There are pictures, and the pictures will be disseminated. I'll send one to you, or words to that effect, that significantly upset the selectman's wife, and brought pressure to bear on the selectman himself, who was concerned with his wife's safety and health and well-being.
Yes, if I just may clarify, I don't think he was asking him to resign. I think the writer was saying, you should resign, you are not qualified. So he didn't ask him to resign, he just said, you are.
That was, his resignation was the object of these letters, I take it. That's what he was trying to accomplish.
Well, I don't think so. I think his object, his purpose in writing was, you are a lousy selectman. I don't like you. You are not qualified. The town doesn't like you, and you should step down.
Well, he was trying to get the selectman to resign. It was one of the things he was trying to accomplish.
He says that, doesn't he?
Well,
It says that in the letter.
yes, I guess he says you should resign.
And he
but-
also suggests to the selectman's wife that he's having an affair with at least one other woman, and that there are photographs to prove it.
Yes.
And he's upsetting the, those kinds of words would upset the selectman's wife.
Yes.
And in fact, he encourages her to leave him, to ditch him.
Yes, he does say you should,
Isn't
yes.
that the kind of conduct, or isn't that conduct that takes this beyond protected speech?
No.
So you could do that. This is
You can do
perfectly
that.
permissible.
Yes, it is, Your Honor. The fact that he says your husband is a cheat and a scumbag and you should leave part of him at the curb,
And I've got pictures to prove that he's having an affair with somebody, and I will send these out.
those pictures never surfaced.
Well, but the letter, just the fact that she's married to him, she has no rights to claim that this is harassment?
No, I'm not saying that. I'm saying that that's sort of a different issue, whether or not she was targeted. Of course, the statute requires that the defendant target a victim on 3 occasions. So when and where has the defendant in these writings targeted
Well,
Mrs.
he's
Costello?
addressed the letters.
2 letters are addressed, the envelope are addressed to Mrs. Costello.
Is
Well,
it
5.
five?
Well, yes, I'm sorry, five.
Her name is on 5 of the envelopes.
That's right. 5 envelopes. The first envelope is Mr. and Mrs. That's correct. But there are actually 2 letters, letters 3 and 4, that are specifically addressed to Mrs. Costello, her home address. One letter, it's not even a letter, 1, 2, and 5, they are not letters. I'm using the word letters. They're actually sort of memos. Letter 5,
Stuck in an envelope that had.
That's right.
And her name is on the, he
That's right.
intended the post office to deliver that envelope with its contents to Mrs. Costello.
yes, yes, but when we look at the content, which I think is more important than the actual recipients on the envelope, when we look at the content of letter 1, 2, and 5, Susan is not, Mrs. Costello is not even mentioned. In fact, she's not even really mentioned in 3 and 4.
Well, is it reasonably inferable that he intended Mrs. Costello to read the contents of all 5 envelopes?
I think by the fact that 4, and the first one, which was Mr. and Mrs., yes, to read it, yes. But did he target Miss?
And what was, is it also inferable that she would likely be upset, at least upset, by the contents of those envelopes?
No, and the reason is that the Commonwealth even concedes that Mr. Costello was the subject of all letters, not Mrs. Costello. There is no doubt that there is a reference that your husband is a cheat and a scumbag and says something else. Yes, it says that. But the 5th letter, for example, is directed towards Lorraine. Mrs. Costello is not even mentioned in any of the letters, with the exception of that one, and she's not even exactly referenced.
Well, there's a handwritten note on the letter to Lorraine, and it's addressed to Mrs. Costello.
That's right. In letter 5, yes, it's the letter itself is typewritten. It says, "Hey Lorraine, post this on your blog," and then it goes on about how Mr. Costello is not doing a good job. And then handwritten on the right-hand corner, it does say, "Susie - preview of what's coming." Yes, yes, it does.
Are you saying that you can't be the target if the information that is sent to you and directed to you concerns somebody who's very closely connected to you, a spouse, a child, or something like that? It has to be you directly? I mean, why can't you be a target when some very close member of your family is getting attacked in this kind of way?
Because looking at who the envelope was addressed to is not enough. We have to look at the content. And letter one...
Well, I am, but I mean...
But she's not mentioned.
No, but that's my point, is that she can't be a target when the contents are focused on somebody. Let's just say it's a child, and it has a whole lot of stuff about a child that's very negative, maybe threatening. It's not threatening to her, but she can't, but...
Yes, I understand. That is not free speech. This is political speech. So in that instance, I think that's completely different, making up lies about your child. But this is all political. It is political speech. And the Commonwealth conceded at trial, all 5 letters are about displeasure, the writer's displeasure with the selectman's performance.
But he's not, his performance as a politician is being criticized by virtue of his performance as a human being, as being, unfaithful to his wife, about being a felon. It's not about, you're a bad politician because you've stolen money necessarily, or you're a bad politician because you take positions that are anathema to me,
Or corrupt,
or you support abortion rights and I don't, and you're immoral. I mean, it's not anything that's that specific to his. I mean, I suppose the ones about him being a convicted felon and why, if if believed, it could have something to do with his performance as a politician. But I'm having trouble seeing why some of this stuff is political speech as opposed to just gossip mongering.
Because the purpose in writing is to say that you are not qualified, and part of not being qualified is looking at his moral character. So when he rings up things like you're a felon, you're a cheat, you're a liar, and you've had extramarital affairs, all of that is going to you, selectmen, are not fit, morally fit to assume this position. And you've made lousy decisions. They talk about the Trambella decision and 40B housing. The writer mentions all of these things, how he makes lousy decisions and he's not fit for office. So the writer does incorporate, as I say, personal jabs, these personal comments, but it's all for the purpose of establishing that this man is not qualified to be a selectman. I see my time's running out. If there's no other questions, I would just...
Your time's actually up, so...
Oh, okay, thank you.
Thank you.
I would rest on my brief otherwise. Thank you.
May it please the Court, David Mark for the Commonwealth. Between May 9th and July 23rd of 2011, Mr. and Mrs. Costello received 5 anonymous letters at their home. The first letter was addressed to Mr. and Mrs. Every subsequent letter was addressed to Mrs. Costello. 2 of the letters are specifically addressed to Mrs. Costello. The 5th letter has a handwritten gloss. It's written to Lorraine. Not clear who that is in the record, but it's clearly intended for Mrs. Costello because there's a handwritten gloss to that effect on the letter.
But you agree, don't you, that all of the subject of all of them really has to do with the husband being a lousy selectman?
Absolutely. I completely agree with that. I think it doesn't matter for purposes of whether or not these letters constitute harassment.
You don't think that matters at all? That suppose these letters were just a barrage of, you are an immoral person because you support abortion rights, just continually harping on that, and that I will do everything I can to get you out of office. I will trail you everywhere and hold signs up showing that you're a killer, or words to that effect, that somebody could be worried about, but it's clearly because of somebody's disagreement with positions that they've taken. You
Yeah,
don't think that would make any difference
No,
at
it would
all?
make a huge difference. The hypothetical you've created, though, Your Honor, is very different from the case that we have. In that instance, let's assume that, that the letters are still anonymous, they still go to the home, but they deal exclusively with the anonymous writer's dissatisfaction about a position that the politician has taken on an issue. That, I think, on its facts, lacks the unsettling quality, the deeply unsettling quality necessary to actually meet the statutory requirements.
Well, given what's happened with so many people who are engaged in the abortion debate, actually, I would think that it could be
All right.
a highly emotional reaction.
You make a very good point. So having chosen that as your example, and in the context where so much violence has been visited upon people who are pro-abortion, yes, so it really depends on very closely on the facts of the letter in your hypothetical and the alteration. What I would say about where we are here with this letter, though, is that despite the fact that the writer's dissatisfaction and anger grows out of sort of the political environment, that doesn't matter for whether or not these letters constituted as a pattern punishable harassment.
Can we take the two victims separately?
Yes.
And just take Mr. Costello, elected selectman, and let's just assume that all these letters came only to him. I mean, a lot of the contents is about, it's, for example, very critical of the fact about whatever was happening with the police chief in
Right.
Rehoboth.
Well, letter 2 in particular.
Yeah. I mean, what's harassing about that? Isn't that about his political position?
Yeah, if that were all there were, but there isn't. That's one letter out of the 5.
Okay.
So, but your hypothetical is all the letters go to him and all the letters are about him, rather than what we do have.
Yes,
which
yes.
is-
So, but I
mean,
just want to focus on him.
Right. So a critical, and I'll address that, but a critical component of the case from the Commonwealth's point of view is that the letters being to the wife evidence the desire to inflict pain.
Okay, so,
That's-
and then that would be pain to him, too. That's what you're saying.
Right. And in fact, it's picking the vulnerable target is part of the basis on which we bring the charge. So here, your hypothetical is the harder target is picked exclusively. And that's a much harder case for the Commonwealth to
So
meet.
the harassment is the infliction of pain?
Well, so
It's got to be a
look at-
threat, doesn't it? It hasn't to be a threat, or it has to be...
No, it's not threat. The threat is you're into the stalking universe there, Your Honor.
So you're saying merely
No, it's a
painful statements are sufficient?
The requirements are that, in particular, that the person suffer real emotional distress, and then a reasonable person would be subject to a substantial emotional distress. So there has to
Speaks
be
about alarm.
subjective real pain.
Seriously alarms that person.
Yes,
What do you
seriously
think? What do you
alarms.
think alarm means? Does an alarm require some fear of physical violence or
No,
property
not
damage?
necessarily. It could simply be fear of physical encounter.
Okay, fear of physical encounter, but fear of some exercise of force against that person.
I don't think force is necessary.
Some
or
physical
some
connection.
confrontation, if you will, perhaps.
Well, but I mean, this is part of the problem. I mean, if we're going to say painful statements, what if they're true painful statements? What if, in fact, the statements are painful but true?
So
Doesn't matter? Doesn't
I
does
would
it
say
matter
no.
in your work?
Supposing the selectmen were enormously overweight, and the letters were a series of particularly ugly jokes about his weight, that could still inflict the necessary pain to
Okay. What if he? I don't know whether he's a felon. What if he is a felon, and the person says you should know that your husband is a felon. You should know this. You should know that. All true. All painful. Harassment.
So I guess the answer is it depends.
But it depends on what, though?
Supposing that this is the conviction has been sealed, so it's
Okay, so it's conviction
now
sealed,
there's a
but it's
revelation
true.
of it.
Okay, so let's assume it's a sealed conviction.
Yeah,
You
but-
should know that your husband was convicted when he was not, as a juvenile. You should know that your husband is seeing somebody else. You should know that your husband has defrauded this poor fellow who's trying to get 40B housing.
Right.
You
And
should know
what
that.
what is the purpose of these letters? The purpose is to inflict emotional pain on the recipient and on Costello by making his wife unhappy.
Can I
Well,
take
also
you
to get
back
him to resign.
I have a question. I'm trying to understand how we separate political speech from the kind of speech that you're talking about? I mean, why is it that this isn't political speech because it's about him as a person or allegations about him as a
Commonwealth's
person?
view is that in this case, we're dealing with speech that is integral to conduct intended to cause substantial emotional distress. That the purpose of the...
Are you saying that you can't do that with political speech? I mean,
No,
when you say bad things about a politician, a lot of them do experience emotional distress from
Right,
that.
and I think it's possible that sort of, that I would say that baked into the definitions of willful and malicious as the appeals court interpreted that language in O'Neill, and that language from O'Neill has found its way into the instruction in this case, that there is some consideration given to sort of, as it were, the nature of the target and the reasonableness of the criticism, reasonableness of the conduct. So I haven't been as clear as I should be. So let me just back up for just a second. So I'm sorry, I'm trying to find the exact language I wanted here.
You can go ahead to something else. That's
No,
that's fine.
I didn't mean to get stuck on this, but I think it's an important point. The point I'm making, and I'm not finding the language I was looking for, is that the way in which the statute is drafted and the way in which the juries are instructed on it protects from the kind of harm that you are concerned about, which is that you're being punished for political speech. Where the speech is plainly or arguably political in nature, even if ugly, then I don't think the Commonwealth can meet its statutory requirements. So I think there's that.
But political in nature is a very slippery slope, because political, you can say that somebody is not qualified to hold office because of moral considerations,
Right.
not having to do with positions that the politician may or may not take. You can simply say, you are you haven't told us that you're a convicted. I mean, listen, when Judge W. Bush was running for president, there were allegations made about early drug use, having nothing to do with any position he was articulating about foreign policy or anything else, but about his fitness for office. Why aren't those kinds of comments political in nature?
I think they are.
So here, when they're talking about, his infidelity, his prior criminal past, his dealings on the housing situation, and all these other things, they go as much to fitness to hold that office.
No, I agree,
as
and absolutely.
even though they're harsh and they may be hurtful and all the rest of it, why isn't that political speech?
So I guess the answer is it is political speech.
But that doesn't matter.
But political speech can, depending on the context, can nonetheless amount to harassment. If it's political speech incidentally to the intention to inflict substantial emotional injury,
Boy, is
then
that's a hard line to draw.
well, but
So you're saying
Yeah,
that when they were contemplating publishing this information about draft evasion and drug use, that you could say, well, if your purpose was to inflict pain upon Mr. Bush, then that would make you a criminal?
no.
And I mean, isn't there a risk of chilling speech if we have to focus on whether or not your intent is to inflict pain?
Right. So I'm trying actually to suggest that the political speech should be interpreted quite broadly here. In order to preclude the possibility of the use of such a statute to chill political speech, but in this case, so what's the touchstone here? The touchstone is what's the purpose of this conduct? It has to be intentional and malicious.
The conduct is the speech.
Sorry?
The conduct is the speech.
Yeah, well, the conduct is speech is integral to.
Well, when you say the purpose of his conduct, what conduct are you talking about? If you're not talking about his
it's the
speech?
mailing of anonymous
Delivery.
letters to the home.
It's the mailing of these letters to the home.
And addressed also to his
Mailing of
wife.
anonymous letters to the home. It's important to look at the whole picture here
But you
in
need
determining whether or
the
not.
letters to the fact that the letters had gone to Mrs. Costello is an essential component of your case.
Yes. It's an essential.
That's where it
that,
starts.
That it goes to the home, that it goes to the wife, that the two are addressed to the wife. That is essential to the Commonwealth's proof that the point here is to inflict the emotional injury, that it's not, in fact, about making a political statement. These are not public statements. There's a threat of publication in at least one of the letters, but there is no publication that we're aware of in the record of this case. Right?
So if
they don't go to the office.
If he wrote a letter to the editor saying all of this,
But
and his intent was to inflict pain upon,
that's not actionable. Correct. It's
so I'm trying to think what the distinction
here
is
the
here.
fact that
Because it was sent to his home and was not published, that it was, your focus is on the intention to inflict pain. It sounds as if you more likely to actually inflict pain if you publish it.
I think, as I say, sort of baked into the statutory requirements is a sense that some attention must be paid to the circumstances of the intended victim, if you will. And a politician isn't necessarily a sort of more robust target for this. A certain amount of this calumny, it comes with the job.
So-
And so in terms of whether a reasonable person in the victim's position, I'm sorry, Your Honor, whether a reasonable person in the victim's position would reasonably feel substantial emotional distress, it would be hard for the Commonwealth to make out a case that a politician who's being criticized as a politician, particularly in a public forum, but maybe even in a private letter, would be legitimately, whether a reasonable person in that person's position would be feeling.
So is it, if I understand correctly, it's, as in Johnson, I mean, this part is Johnson, is the same. I mean, we're dealing with speech versus conduct to start.
Well,
and then,
not versus. It has to be conduct, but speech can be integral to the conduct.
right,
Yeah.
right. But the argument is that the speech, I mean, the argument of the defendants in Johnson and the defendant here is the speech is the sort of governing part, and you can't chill it in this way. And I guess all I'm saying is that, at least as I understand the argument being made by the defendant here, it's not just speech, it's political speech, so it's an even higher level that you've got to worry about what is that relationship between the conduct and the speech. And you're just saying, yes, it is a, at least I think you're saying, there's a continuum here, and you are looking at whether it's integral, and that's a case-by-case determination. But I guess my question is, does then it become a jury question about where the First Amendment line is? I mean, I'm just not sure how we deal with this in a. Does the jury get to weigh in on whether this qualifies as political speech or it doesn't?
So I think it's both. I think it's both a question for this court and a question for the jury, because it certainly can be raised below as a defense, right? It might have been in this case. If the defendant said, well, yes, I wrote the letters, but my point was, this is a bad guy, he shouldn't be our selectman. And my intent was not to, oppress him, to cause him psychic pain. My point was just get out of town.
So put aside the political speech. Let's imagine it's a workplace. You got, and I can't stand somebody, and I make 3 statements about them, very hurtful, all true. I tell my coworkers with the intent that they should hate him too. Harassment? All true. Because because I really can't stand the person, I intend to inflict pain upon the person. I want my coworkers to hate him too. Is that criminal harassment?
I think the answer is no, but I'm not sure it depends on the fact of the truth or falsity of the statements.
Okay, so let's assume they're all true. I make 3
all right,
statements
so
to
it's
say, I
statements
hate
about
this
his
person, and you should hate him too, because this person did A, B, and C.
So my answer is the Commonwealth, if they bring the case, have to run down the requirements of the statute, the elements, and make sure that they're all met. Is there, in fact, the necessary willful and malicious intent?
Yeah, I hate him. I want them to hate him too. That's enough?
Well, no, you have to intend the harm.
What's the harm?
So if you do, then yeah, maybe you do have a case.
The harm is for them to be ostracized. I want them to I hate him. I want them to hate him so that he'll be ostracized.
So it's not getting other people to hate. It's the victim has to be the subject of the distress and reasonably feel that distress. So the answer is, I'm not sure, but I think you may actually have created an instance where, yeah, that legitimately could be brought as a harassment case. I certainly don't think it depends on truth per se. As I say, you can pick on a true fact about someone in a way that's so hurtful that everyone would understand that the point was to distress the
So
target.
it would not be defamation, but it would be
Not be-
harassment.
I think it's a red herring to go down the New York Times versus Sullivan route. That's not at issue here.
But it's very restrictive of speech. What you're saying is that the statute, construed the way that you're construing it, is very restrictive of speech. Very restrictive. You know, that ordinary social intercourse, like Justice Gantz is describing, which is not the pleasant side of human beings, but is hardly one that the criminal law has ordinarily regulated, is troubling.
Yeah, so that's not the impression I wanted to leave the court with here. In fact, you know, I would say as a representative of the prosecution is we want to create a broad protected space for political, in this case, political speech. I certainly,
I think
it was
I
not my-
understand your point, that you want to do that, and that in this case, when you're talking about someone's wife and then picking on characteristics of a wife and calling her an effing and so, and picking on those, and then sending it to the home every other week for a period of 5 weeks. I mean, even loving letters can be considered, as we know, threatening letters, and this was certainly not loving. This was malicious, is what you're arguing,
Right.
and designed to cause alarm and say, I know where you are, you should move, I'll know where you are then, don't worry, I can find you, you know, don't show up. All of those were couched in this kind of frightening, I know you, I know about you, and this won't stop.
Thank you, Your Honor, that nicely summarizes my position.
All right, thank you. We'll take our morning break.